Honorable Court. Please be seated.
Thank you, Madam Clerk. Good morning, everyone. This is the September session of the Tennessee Court of Criminal Appeals here in Nashville. My name's Robert Wiedemeyer. I live here in Nashville. My colleagues today on this panel, to my right, Judge Robert L. Holloway, Jr. from Columbia, Tennessee. My left, Judge John W. Campbell, Sr. from Memphis, Tennessee. We have read the briefs. I want you to know that. The records will be made available to us, obviously, after arguments. Each side has 20 minutes. If you represent the appellant, and you want to reserve some rebuttal argument time, let us know on the front end, please. And that'll be subtracted from your 20 minutes, and then the clerk will help keep up. I will too, but we do have the lighting system up here that'll help you figure out how much time you have left. I think that is all the announcements I need to make, except just like to take a moment before we get started with the first case. On August the 17th, one of our longest serving, in fact, the longest serving colleague on our court passed away, James Kerwood Witt, Jr., and we will miss him, and I know those of you who have practiced in this court will also miss him. Judge Witt was extremely intelligent and astute about these issues, and to be honest, every now and then he could come across as a bit curmudgeonly about things, and I think he would be happy to hear me say that, although he would also be happy to hear me say underneath that occasional crustiness, he had a very friendly, good, loving heart, and he certainly loved the law and served this court well for about 27 years. And so he'll be greatly missed. And I'd like to just take a moment of silence, please, to honor Judge Witt and his memory. All right, thank you. Are there any preliminary matters on the docket?
No, Your Honor.
If you'll call the first case, we'll get started.
State of Tennessee versus Brian Tremaine Mitchell.
Good morning.
Good morning. May it please the court, I am Emma Ray, tenant of the Nashville Public Defender's Office. I am appearing on behalf of our client, Mr. Brian Mitchell. If I could reserve 4 minutes for rebuttal, please.
Certainly.
Thank you. And just to note, Mr. William Allensworth originally represented Mr. Mitchell on appeal and wrote the brief that we are here on today. He has accepted a position at the Federal Defender's Office here in Nashville, and they are very lucky to have him. Mr. Mitchell was convicted here in Nashville of murder, attempted murder, and the use of a firearm in a felony crime of violence. At trial, he challenged the state's proof of his identity as the shooter. On appeal, he raises 5 issues concerning the admission and exclusion of evidence, and he raises a related issue concerning an admitted jury instruction. I plan to spend most of this argument discussing the trial court's decision to admit contested hearsay evidence as a dying declaration and its related failure to provide the jury with a cautionary instruction as to how to receive that evidence. If time permits, I hope to also touch on the trial court's other evidentiary errors, which, as our brief does contend, should cumulatively result in the reversal of his convictions, And of course, I welcome any questions the court may have on other issues that I don't explicitly get to in my argument. Prior to trial, Mr. Mitchell asked the trial court to exclude several statements made by LaQuisha Terrell, the victim in this case, to Officer Garrett Latham, made at the scene of the shooting. These statements were, concisely, I'll just go through them. A statement to save my baby. Ms. Terrell was approximately 6 to 7 months pregnant at the time of the shooting. And then she, after Officer Latham was administering first aid to her, he asked the crowd around her if anyone could describe the shooter, and she said it was Brian. At that point, he began explicitly questioning her, asked for her last name, the nature of their relationship, and his date of birth. He wrote that information down on a latex glove he was wearing as he gave her first aid. He later preserved that evidence by taking a picture of it. At a pretrial hearing, he was asked about, and we'll get to this a little bit later, but just to lay out the sort of pretrial preliminaries on this, he asked about the primary purpose he had in collecting this information, and he said, well, first I'm trying to save Ms. Terrell's life, and I also want to catch the person who shot her. He did not broadcast that information immediately out on the radio. He stayed on the scene and just took a picture of his glove. We challenged those statements as inadmissible hearsay evidence, and the trial court held that they were properly admitted as dying declarations. Because we also challenged them as in violation of the Confrontation Clause, because the trial court found that they were dying declarations, it did not undertake a full analysis of their testimonial versus non-testimonial nature, because a dying declaration is not subject to the Confrontation Clause analysis. It sort of steps outside it.
If I remember correctly from the judge's order, when he entered his order on after the hearing, he found it being a dying declaration. He also found it was an excited utterance.
Yes, that's correct.
And if I understand correctly, y'all aren't appealing his finding that it was an excited utterance and it was admissible under that theory.
That is not subject to this appeal, just that it was a dying declaration, and then also it should have been held as testimonial, and our position is that as a testimonial evidence, it would have been subject to exclusion under the Confrontation Clause.
Let me ask you this. Couldn't it be inferred from Mrs. Terrell's statements, and if I remember them correctly, she was concerned about the fetus dying,
Yes, sir.
which could indicate that she may be concerned that her injury would cause the fetus to die rather than the fetus actually being hit by the bullet. Doesn't that provide circumstantial evidence that she thought that death was inevitable, or whether it was or was not may not be important, but that was her mental state?
That's a very excellent question, because that is something the parties discussed and the trial court discussed at the pretrial hearing, and the trial court touched on in its ruling. The parties both acknowledged that that statement, in view of the dying declaration requirements, was ambiguous. It could be interpreted one way, like, I'm doing okay, save my baby first, or my life is in peril, do what you can to save my baby. The trial court, in its order, frankly acknowledged that ambiguity, but simply found that she believed that she was dying. That was the trial court's finding, and didn't really resolve that ambiguity one way or another. Just said that it existed in the proof, and I think it does exist in the proof. And again, at the hearings and in their motions, both sides acknowledged that statement could go either way. Before I launch completely into the analysis under the dying declaration, I want to touch quickly on the applicable standard of review, because the state's brief notes a different standard of review than the one we've taken, that we've argued is applicable in this case. It is our position that under Kendrick versus State, the standard of review for a hearsay ruling by a trial court, well, it's actually subject to multiple layers. The trial court needs to make findings of fact as to the question of, was the statement hearsay and is an exception applicable? Those findings of facts generally have to be accepted by an appellate court unless the evidence preponderates against them. But once you have those findings of facts, the application of those findings to the law is subject to de novo review by this court and not an abuse of discretion review. Here, the statements were clearly out-of-court statements. They were offered for their truth, and the question before this court is, were they subject to the dying declaration exception? And the one thing I'd like to remind this court is that the case law on this issue is unusually strong. It has unusually strong language setting out the metes and bounds of this exception. It's not, it can't just approach it. The evidence has to show that the declarant, the victim of the homicide, believed with certainty that death was rapidly approaching. Not that, as a trial court found, she was fearful of dying, and I don't want to minimize the obviously serious nature of her injuries at the scene, the serious efforts of responders to administer first aid to her that included both civilian and law enforcement responders, but the proof did not clearly show that she had a certain belief in her rapid death. Certain belief that death was imminent are the two, certain and imminent are the two adjectives that I'd like to emphasize for the court, because the dying declaration has a certain solemnity to it, and you have to meet that hurdle. And I would suggest that the circumstances at the scene of the shooting and then the trial court's findings about those circumstances do not meet that hurdle.
Your position is that very issue is to be reviewed de novo?
The application of, well, the trial court did not make the required findings, and so I would suggest that those facts are not there to support the trial court's, yes.
I know Judge Witt, speaking of Judge Witt, he wrote the opinion, I think, that it laid out exactly what you said about how you analyze the hearsay. And so you're saying there's some factual findings that are basically inadequate by the trial court about this key issue of, did she believe that death was about to happen?
Yes, sir, and I've always admired Judge Witt's incredible precision with language, and I think here, we're not disputing that she was fearful of death, just that we're not arguing that this court should find that the evidence preponderates against Judge Dozier's findings.
Right.
We accept Judge Dozier's findings as fact. However, we do not believe that finding, fearful of death, meets the high bar set forth in case law going back, centuries at this point, for a dying declaration.
So that becomes a legal issue reviewable de novo?
Yes.
Okay.
Yes.
I
yes.
got you. Go
Close that circle. Yes, that is what that becomes.
All right.
Let me stop you for a second. And, let's say that the judge was in error in letting this in under a dying declaration, but he let it in under another theory that is not being appealed. So it comes in anyway, right?
Our position on that, Judge Campbell, would be that to the extent that it was also allowed in as an excited utterance, that our confrontation clause analysis should have excluded that. An excited utterance can be testimonial.
But didn't the judge talk about the confrontation issue and found that it was non-testimonial in his order?
He did. He made a finding that it's non-testimonial. That order lays out 3 findings: that it's non-testimonial, that it was a dying declaration, and it was also an excited utterance. However, our position here is that his reasoning or his analysis of the non-testimonial testimonial issue was not a complete analysis, because he found it was a dying declaration.
But he also found it was an excited utterance. And that's where I'm trying to, I guess, put this in perspective for my tiny brain, in that, he found it was admissible under 2 theories.
Yes.
You're objecting to one theory and not appealing the other theory. So to me, it seems like it's going to be admitted one way or the other, and the other way you're not appealing.
Well, we are appealing it sort of indirectly, as our position is, and this is in Mr. Allensworth's brief, it was testimonial, that its primary purpose was not to, that his primary purpose in questioning Ms. Terrell at the scene was not to deal with an ongoing emergency, which...
Well, at that point in time, though, the perpetrator was on the loose. And my recollection under Crawford and the cases that come out of Crawford was that is one of the areas where the court has found it was non-testimonial if it was an ongoing emergency, such as a perpetrator is on the loose, the police are trying to figure out who it is. Obviously, the person is armed and dangerous. That took it out of testimonial as opposed to a call after the fact, a 911 call saying, hey, you know, yesterday this happened and here, then that was considered to be testimonial. So this one, they're still trying to figure out who the suspect is who's on the loose.
I agree that no suspect had been apprehended at that point, but I think under Michigan versus Bryant and Davis versus Washington, the courts have asked us to look at the statements and the actions of both the declarant and the interlocutor, the questioner. And here we have an officer who is asking pointing questions, trying to nail down the identity of a suspect. He is preserving that evidence on his glove. He takes a picture of that evidence to preserve it as evidence, and he does not, at that point, turn around and put out an APB on the name, any description he might have gotten, and date of birth, et cetera, of that person.
But at that time, he was still rendering aid to the victim.
Absolutely, Your Honor, absolutely. And at the pretrial hearing on this, he stated, when asked what was your primary purpose in doing this questioning, he stated, my primary purpose was to render aid to Ms. Terrell and to catch the person who did it. And I would suggest that that means he was trying to preserve evidence for future prosecution, and it should be excluded under the Confrontation Clause analysis, that it was testimonial. At least very much of it was. Once he started questioning her, all of that's testimonial. I don't have much more time, and I'd like to get quickly to the issue of the omitted jury instruction. Here we are not contesting that we get plenary review of that error. We did not request it. However, we do believe it rises to the level of plain reversible error. It was the record is clear, what happened in the trial court. This instruction has been deemed fundamental by cases, again, going back 100 years. It is designed to alert the jury to how it should weigh and consider this very rare exception to the hearsay rule known as a dying declaration. It gives very specific, it's a lengthy instruction, several paragraphs. It gives very specific instructions about how to consider the fact that this information came from others, that it may not have come from a calm, attentive person, declarant, that they should consider the reasonableness of the statement and evaluate any contradictions, bias, or interest, and remember that the accused was not able to cross-examine to show any issues with memory or perception or passion or prejudice. A substantial right of the accused was adversely affected. A right to a complete and correct jury charge has been deemed substantial, and in fact, it rises to the level of a constitutional issue because every criminal defendant, as part of their right to a trial, has a right to a complete and correct instruction on the law. The trial court's failure to do that does impair the defendant of a constitutional right. Here, there's absolutely no evidence that the parties, that the defense waived this instruction for tactical reasons. They litigated the dying declaration, all of the hearsay, very, very rigorously prior to the trial. And finally, consideration is necessary by this court for substantial justice. It was a very weighty trial, obviously serious issues, a lengthy sentence, and this was the most significant proof, as demonstrated by the way the state used it in closing argument. The most powerful evidence of guilt in a case that came down to, it was an identification defense. And this identification evidence was used by the state very comprehensively during their closing arguments. I suggest that the plain error factors are met here. And the trial court had a duty to instruct the jury as to how to evaluate a dying declaration. It has been called by Burleson versus State, Tennessee Supreme Court in 1973, as fundamental as the right to an instruction on reasonable doubt, as a right to instruction on a fair trial and other such very fundamental aspects of a trial court's instructions. With that, we'd ask this court to reverse convictions or remand this case for a new trial. Thank you.
Thank you. Good morning, sir.
Good morning. May it please the court, counsel, my name is Will Lundy. I'm an assistant attorney general and I represent the state of Tennessee in this appeal. The state asked this court to affirm the defendant's convictions, and given that my friend has spent the majority of her time speaking about the admission of these statements, I would like to do the same. Even if Ms. Terrell's statements to Officer Latham were not dying declarations, the trial court also admitted those statements as excited utterances, and the defendant has not argued that the trial court erred in or abused its discretion in having done so. The question here is not so much whether the statements were dying declarations, is were they admissible at all? And again, the trial court found that they were admissible as excited utterances. The trial court also found that they did not violate the confrontation clause, and the statements therefore are admissible, and the defendant has simply not argued that they weren't admissible under that theory. The defendant has argued here that the confrontation clause should have barred admission of these statements, but again, there's no, she's made no argument that they were not admissible as excited utterances, which needs to come first. And secondly, the defendant did not put the confrontation clause in his statement of the issues, and this court has routinely found that issues that are not placed in the statement of the issues are waived. Accordingly, we would ask that the court find that that is waived. At a third point, the statements other witnesses also identified the defendant as the shooter. Not only did Officer Latham testify about what Ms. Terrell said, but Ms. Khalil, one of the eyewitnesses, testified as she was asked by the victim to call her mother, and she stood there with the victim's cell phone and called the number that the victim gave to her, in order to inform her mom, and the victim told her mother that the defendant shot her. Ms. Khalil testified to that. Ms. Terrell's mother, LaTora Terrell, testified to that as well. And again, the defendant has made no argument that those statements don't come in. Accordingly, even if the trial court was wrong when it admitted the statements, or when it held that the statements were dying declarations, the statements were nonetheless admissible, and even if they weren't admissible as dying declarations, they come in through other witnesses that just are unchallenged. And as to the jury instruction, Your Honor, and Your Honors, I apologize. In my brief, I think I relied mostly on the waiver issue, but this court does conduct plain error review. And I would argue that this does not rise to the level of plain error. On plain error, the error must be of such a great magnitude that it probably changed the outcome of the trial, which is to say here, if the trial court had instructed the jury in all of the ways that my friend has spoken about, that the defendant would not have been convicted. We're not talking about the difference in intent or in the difference between a first-degree murder and a second-degree murder. We're talking about the identity of the defendant. And again, the trial court found, first of all, that these were excited utterances, and there's no jury instruction on excited utterances that is the same as the dying declarations instruction. So, I mean, it's harmless on that front. And secondly, the evidence is so overwhelming that the defendant was the shooter in this case that it's just not necessary to do substantial justice to review that issue. And I would ask this court to refrain from doing so.
Help me remember this. Is this jury instruction part of the pattern jury instructions?
As far as?
The one that they are saying should have been given about how to assess dying declarations. All three of us are former trial judges, and basically our Bible on the bench is the TPI instructions. Mm-hmm. And I can't remember if there is a pattern instruction that pertains to this issue.
I have to confess, Your Honor, I don't know the answer to that question, and I apologize for that.
Makes me feel better about not knowing, that's fine.
I simply don't know. I know it is there, certainly in the case law, but as far as whether there's a pattern, I couldn't tell you.
This tenant will know when she comes up to
I'm
rebut.
confident that that's
Yeah.
true, yes.
All right.
If the court has no further questions for me, I'm prepared to cede the remainder of my time. One thing I would, if the court would permit me to say one thing that's a little off topic.
Certainly.
Thank you. The record in this case was kind of a mess when it came to this court. There were some transcripts that were not only not from this case, but had been altered to include the defendant's name, and it really was a mess. And Mr. Allensworth did a remarkable job, in my opinion, of ironing all that out so that the court could have a clean record, so that I can have a clean record, and I wanted to say thank you. He's not here today, and I regret that I can't say thank you face to face, but I wanted to say that, so.
Appreciate those comments, and both briefs were excellent in this case as well. So I know we don't really have enough time to cover everything in oral argument, but it's been well covered in the briefs, so from both sides. Thank you.
Yeah. So again, does the court have any further questions for me?
No, sir.
If not, then I would ask the court to affirm the trial court, and I will cede the remainder of my time. Thank you.
Thank you, General.
I want to begin by acknowledging the record, and I am in complete agreement with Mr. Lundy about the work that went into making this record as clean as it is. And I want to say, when I was preparing this argument, I continued to encounter transcripts that were from different cases and different hearings, and it was very confusing. I do appreciate the efforts that went into that. Our position on the state's argument that we've waived the Confrontation Clause issue in this brief, what I would say there is the issue statement uses the word testimonial hearsay, and that phrase means a Confrontation Clause challenge. And I do not believe we waived the issue by using that phrase instead of something more complete when we had just, days and days of litigation, pretrial motions, and during the trial on that issue. Yes, there were other witnesses at the scene. I would submit that the officer's testimony was unique, and it was particularly powerful. He was an officer of the law. The state relied on that evidence. It was accorded very heavy weight by the state throughout the trial and in their closing arguments.
But there were two other witnesses who testified about what she said, and that were not objected to.
There was a witness on the scene.
Correct.
Some of her testimony was impeached because she, at a later point that evening, identified the shooter as someone named Chris.
I understand.
And that had to be cleaned up. I don't think you can give as strong weight to that. And then there was also Ms. Terrell's mother, who was on the other end of the phone, and she did hear.
But again, that's going to be the jury's decision about how much weight they give to those.
Absolutely, absolutely.
And we can't say for sure how much weight they put on any particular witness's testimony.
I would just like this court to remember that an officer who wrote things down, took pictures of it, was there dedicated to that task, may have a different weight and should be possibly viewed differently than the civilian witness on the scene who did get some facts wrong at some point in time, and also the mother who was on the phone and obviously under her own duress and stress. The harmless and sorry, I'm jumping to the instruction and the question of whether or not the trial court's failure to give that instruction was harmless error. I would just like to note that I do believe that this issue does rise to a constitutional question because the right to a complete and correct jury instruction is part of a defendant's right to a trial. And so the harmless error analysis should be viewed under the standards set forth in Rodriguez as a non-structural constitutional error, which places the burden on the state to prove that the error did not impact the jury. And
I'm just asked, did the trial court give the standard instruction as to how the jury is to review any evidence?
Yes, I believe it did, but the next thing I was going to get to, Your Honor, and it looks like I cut you
Okay.
off, and I
All
don't
right,
want to
go
do
ahead.
that. But as everyone predicted, there is a pattern jury instruction specifically set out for the dying declaration. It is found at the TPI criminal at 42.15. I have it printed here. It is lengthy. It is very precise. It's not like those instructions where a trial court is, reminding a jury that something they've heard is for impeachment value only and not for substantive evidence. It's not just reminding the jury of the way they're to hear, that all witnesses are presumed believable, et cetera. It's not the kind of corrective instruction that trial courts get, or that redactions shouldn't interfere with the jury's understanding of audio-visual testimony. It's long, it's precise. It goes into cautionary scenarios that the jury should really, really work through when they hear evidence that has been admitted as a dying declaration. And with that, I think I'm out of time, but again, I would ask.
Let me just ask one
Yes, of
question.
course.
The certainty argument that you made is troublesome to me. So you have a lady that's 7 months pregnant that sees a man walk up with a firearm, shoot her 7 times, 3 times in the chest, 2 in the abdomen, 1 in the thigh, and like 1 in the arm of the hand. And I'm just trying to, so whether or not she was certain of death or had some degree of certainty would be subjective in her mind, correct? I just have a hard time saying how, when she said what she said, she wasn't certain of death. That doesn't mean she has to die, but she did from these gunshot wounds.
The trial court did not make a finding that she was certain of death, that she was certain of rapid death. She did not, again, I don't know that this is completely part of the analysis, but I think it is relevant to note that she died 11 days later. She was receiving, at the time she made her statements, she was receiving several people were administering first aid to her who were professionals, and an ambulance was coming, and she was being reassured that help was on its way. I am not trying to minimize the extremely grievous, serious nature of her injuries, but in terms of that moment and the history of this exception, which really calls, the reason we have it is because it has been our belief as humans for going back centuries. I believe it's even cited in a Shakespearean play that when someone is certain that their moment of death is rapidly approaching, that they have no reason to be deceitful at that stage. So that is the basis for the exception, and as a result of that sort of very grave and weighty situation that allows for that exception, the case law reflects that the situations where it's applied are narrow, where there is proof that the declarant is certain of rapid death, impending, imminent. Those are the words used in the exception itself.
And the baby died the day after the mother, is that correct?
Yes, I believe it was a withdrawal of life support. Yes, Your Honor. Thank you.
Thank you. Counselor, well argued and well briefed by both parties. Call the next case, please.
Aaron Osteen versus State of Tennessee.